staff, visitors in the public tribune, radio listeners, TV viewers, those following via social media, and members of the media. Welcome to this Central Committee meeting number 9 of today, Thursday, January 4, 2024. We have established a quorum of 10 members. Please stand for a moment of silence. Thank you. I have received notice of absence from the following member, MP Angelique Rameau, and I have received notice of lateness from MP Sarah Westcott-Williams. Notifications. I take this opportunity to wish you, my fellow members of Parliament, order in Parliament, please. The Secretary General of Parliament and the staff at the Secretariat of Parliament, faction staff, and the entire population of St. Martin a bright and prosperous new year. Additionally, Parliament received a letter from MP Westcott-Williams, MP De Wever, and MP Gums with a request for an urgent public meeting regarding the state of the voters' registry and the cleaning up of the civil registry with the Prime Minister. Contact was made with the Prime Minister to schedule the meeting. However, due to time constraints on her schedule, the Prime Minister provided an update via a letter from the Civil Registry regarding this. This document is registered under IS IS/2023-2024 dated January 4th, 2024, and has been shared with the members of Parliament. Are there any other notifications? No need. We have as agenda point for this meeting. No, I don't see no. Nobody had it. We have as agenda point for this meeting draft national ordinance containing rules regarding a basic payment account for consumers under National Ordinance Basic Payment Account and Parliamentary Year 2023-2024-174 under document IS/292/2023-2024 dated December 20th, 2023. We go over to the agenda point. On December 20th, 2023, Parliament received the draft national ordinance containing rules regarding a basic payment account for consumers. This document is registered as incoming document IS/292/2023-2024 dated December 20th, 2023. Parliamentary year 2023-2024-174 and can be found on the general themes of Parliament. It is good to note that usually during the handling of a draft national ordinance at this time, we would have the minister responsible present to give some introductory remarks and/or a presentation. In response to the letter of December 29, 2023, inviting the Minister of Finance, Mr. Ardwell Irion, to be present for the Central Committee meeting, Parliament received notice that the Minister of Finance was unable to attend today's meeting. As a result, I have decided that this meeting will continue in the absence of Minister. Members of Parliament will be given the opportunity to pose their questions on the draft national ordinance, whereafter a report will be drafted and sent to the government for further handling as per the legislative process. This report must be answered with the note following the final report, which is to be submitted before the handling of this draft in the public meeting. To which member of Parliament can I give the floor? I see MP Akeem. MP Akeem Arundel, you have the floor.
Good morning, everyone. Good morning, members of Parliament. Wish everybody Happy New Year's. Chairman, I will just dive in straight to it. I would like to know if this law also will protect the person who are rehabilitated in a system within the justice system of St. Martin. And also, I would like to also to know if what documents would be required to open an account. Meaning if it, it would be a simple, only a registration form with an ID. That's about it. The two questions alone.
Thank you, MP Akeem Arundel. The next person is MP Rolando Bryson. MP Bryson, you have the floor.
Thank you, Mr. Chairman. Good afternoon and Happy New Year to all my colleagues, members of Parliament, the Secretary General, and those viewing this meeting. Mr. Chairman, needless to say, it is a very proud moment and happy moment, I think, for the banking or those that have experienced the issues within the banking sector to see that this legislation that I believe is very important to finally making it much easier and fairer for us to do banking in our country. Something that really, I would say, started with the motion of Parliament dated January 2021, in which, in a sort of a co-legislative manner, because of how complicated it would have been for me to do such an initiative law myself without the proper vetting by the Departments of Fiscal Affairs and the Central Bank, I thought at the time fit, with the support of many members of Parliament, to actually have this law vetted and necessarily adjustments to go through the government channels rather than just as an initiative law. I think this shows a good alternative method for members of Parliament to work. We know we have our limitations in terms of how much we can go and how deeply we can go into such a complex and very important law that has to be very technically sound to make sure that it is enforceable, that it is something that the central bank as well as the stakeholders have been able to review to come to an agreement on making this a reality. Just to remind everyone, the motion in January 2021 had requested for the minister as shareholder representative of the CBCS to request that the central bank prioritize the vetting of this consumer banking protection law in such a manner that the 4 key principles stated in the considerations are addressed. The point of that was to ensure that the legislation would still stick to the key principles, which is financial inclusion, having a right to a basic bank account, having it within a fair amount of time, the rules by which a banking relationship can be terminated. One of the aspects that I did not see in this legislation, but from reading the explanatory memorandum, the other aspect being the rules for the publication, transparency, and limitations related to bank charges, is because it encompasses more than just a basic bank account. That would need to happen in a separate legislation, and being that I already had that in the original draft, I believe the method I would choose to do is a similar thing. Bring it forward with the support of members of Parliament to have that part vetted, because I can already see that there may be a reaction that is a trend within the banking sector where fees are continuing to go up. But today we're here to deal with a very important matter, which even in the remarks of the Council of Advice, the SER in Curacao, which did the review of the legislation and the central bank, is that it boils down to financial inclusion. In the surveys that were done in preparing for the vetting of this legislation, which is also included in the law that was presented to Parliament, there was between 17 to 21% of the population, based on different metrics, that do not have access to a bank account in St. Martin. That basically equates to 1 in 5 people within our country not having a bank account. And not for not of a choice of their own, but some of the methods that they mention, or the reasons they mention in the surveys were included, the time that it takes, the difficulty, the ambiguity with which documents are needed or not, and even in some cases, the fact that some people may not have had a job at the moment and they would not be able to present, for example, pay slips or job letters. I think that even if someone is unemployed or retired or a student and don't have those type of documentation, they should have access to a basic bank account, and this legislation does cover that. One of the things that was also an important shift within the kingdom was the Supreme Court verdict NLHR 2021-1652, which is also referenced within the legislation. And this was a court case between a spa in the Netherlands that, due to other investigations or other things that were happening within the country, including tax issues, the bank had decided to close their account. The Supreme Court, however, ruled, and this was an important part of what they stated in that judgment, that contrary to what is stated in section 1.4, the court did not ignore that, the court rightly took the starting point that, based on their social position, banks may also be obligated to offer a payment account to non-consumers. It is also rightly emphasized that without a current account, it is virtually impossible to participate in society and operate a business. This was a very landmark ruling on the level of a Supreme Court, which even in the Netherlands, they made adjustments to Article 471F of the Wet Financieel Toezicht in the Netherlands that gives the right to a basic bank account that has now been extended also to legal entities. And since then, operators, for example, in the Netherlands that operate cannabis shops also were able to use this judgment as a sort of jurisprudence to have their right to a bank account. So even when we look at the jurisprudence side of things, it is good that we're now bringing legislation to enact this within our country. Another important reference point is the European Directive 2014-92 of the EU. This is a European standard that was implemented in 2014 that almost all member states in the European Union have implemented. The Council of Advice have also noted that this legislation falls in line with the implementation of this directive that basically says a bank account should be treated as a basic right for anyone within society. This also was heavily debated in the second chamber recently with the situation that the Netherlands faces with asylum seekers, who also, even in those cases, despite not maybe having an official status within the country, did have rights to open bank accounts based on this European directive and the Wet Financieel Toezicht of the Netherlands. Mr. Chairman, just for the sake of the public and my colleague members of Parliament, I wanted to highlight some of the areas of the law that I think are important in asking the members of Parliament to join me in supporting this legislation. First of all, the legislation makes it very clear that anyone, which is defined as a betaaldienstverlener, so anyone that has a payment service, so even when another law that's on its way, which is the Payment Services Act, that would allow a different sort of financial business that just does, let's say, payday loans and these type of institutions, even they would have to make provisions for a basic bank account. And it says that on their own name, basically by identifying themselves, regardless of even nationality, that they will be able to have the right to a basic bank account. So what is a basic bank account? A basic bank account is an account that allows all payment services available to the bank, which would include interbank transfers, cash withdrawals, ATM transactions, online banking, all of the services that are related to payments. But there are limitations. Some of those limitations, even in my interactions when I first was initiating the law, there are, of course, international laws that we have to abide by in terms of international money laundering laws and counter-financing of terrorism. The main aspect of this basic bank account law is that it does not entitle automatically that you can do international wire transfers. You still would have to go to international vetting process in order to do so, but within the kingdom, you are able to do bank transfers. So that's why it's called a basic bank account. There are some limited areas, for example, where someone is convicted irrevocably of 6 crimes within the penal code, and those are generally very serious financial crimes. Those would be the only persons that may have to go through another vetting process in order to get a bank account. But I believe that this still covers 99.9% of the population, and it is not that they can't get it, but they have to go through a different vetting process. However, the point that MP Arundel brought up is an important one. I think we do maybe have to make it explicitly clear. This is something that, together with MP Arundel, we would want to do, to make it clear that those going through penal rehabilitation should still have access to that bank account, to the right to a basic bank account. I think it's important. That's why we say it is rehabilitation. We want these people to come back within our society. So having a bank account where they can save money, where their family can save money, is an important tool towards their rehabilitation. So I fully agree with MP Arundel on that aspect. However, one other aspect that I think we need to, or I will be proposing as a further amendment, and that is the aspect related to the companies. I think the law is still too ambiguous with regards to the right for companies to be able to apply for this. And the amendment that I will be presenting would be that it also basically, the consumer, the definition of consumer would be extended to a legal entity established in St. Martin. But in order to comply also with the FATF recommendations, such a company would have to be at least owned 50% by someone from St. Martin, so someone registered in the basic administration, or a managing director that is a local as well. So in other words, if an investor would like to come to the country, they would have to go through a regular vetting process. But if they have a managing director that is local, or an investor, or have a partner that is local, then there is that sort of know your customer attachment that the bank has, that someone locally is responsible for what is happening with that account. So I think that is a fair balance that we've been able to strike with the banking sector to make sure that everyone in St. Martin, the legal entities and the natural persons, the citizens, and would be able to get the bank account. Mr. Chairman, I think another important part, which is something others have faced in St. Martin, which is Article 5, which is the ending of the banking relationship. As per the motion, that was one of the key principles we had wanted included. And there are very strict rules with regards to that. Right now, without this legislation, a bank can terminate the banking relationship basically of their own accords, based on their own general terms and conditions. But the banks now, with this legislation, because that is the higher law than their own general terms, will have to adjust their terms to comply with Article 5, which has much more stricter conditions before you can end the banking relationship with a customer. I think, you know, I can understand that a bank has to, of course, do their own due diligence and so on. However, I think just on their own, at a moment's notice, being able to close someone's bank account can have very serious consequences, but for both individuals and for companies. So I think this aspect of the Article 5, where it protects the customer from just having the bank unilaterally decide to close their account, with this law, that would no longer be the case. Another interesting part is that there will be a review of this legislation where the Parliament will still have opportunities by means of a verslag that will be done in Article 6. So that is also where perhaps via the Committee of Finance, for example, we can continue to evaluate what other aspects of banking legislation and consumer protection in banking that we would want to implement. But Mr. Chairman, the point being, really I don't really have much questions. I think MP Arundel covered one of the questions. And the only other point that I wanted to bring up is that this has to be possible for businesses. That can be done with what I see as a very straightforward amendment. But other than that, Mr. Chairman, I'm very happy today that the Parliament of St. Martin is beginning to handle a piece of legislation that would affect thousands of people within our country, where finally we no longer have banks dictating on their own, completely unlegislated, who and what and where people can get bank accounts. I would agree, by the way, with MP Arundel on the proposal, being that the premise of the law is know your customer in order to open an account. We should probably specify very clearly what that requirement is. The FATF recommendation, I think it's 31, says that you have to identify the person and know where they live. So I would say if we follow that recommendation, then the two requirements should be simply proof of address and identification, so ID card, passport, and so on, which for most of us who have done banking outside in the US, in the Netherlands, that is the basic requirement. But this thing about you need now, apparently, there's a new inheritance form that some of the banks are giving you where they want to know what you're going to inherit, the job papers, pay slips, those are things you should submit to a bank when you want loan or when you want credit facilities. But for a basic bank account, with this legislation, we will make it that it is ID card and proof of address. So, Mr. Chairman, again, I want to thank the Ministry of Finance, the Central Bank, the Minister of Finance, the advisory councils, all of the stakeholders and everyone who participated in being able to get this, and also the public of St. Martin for participating in the surveys. I think the participation with the Stat Department of TIAT and the CBCS to get people to give and open up about their banking situations was a very important tool in being able to bring the proper justifications for this law. Because I think without that information, one of the key questions that the Council of Advice asked, what is the need for this law? We would not have been able to answer that. So also to the people of St. Martin for participating in the surveys, thank you, because your information and your openness about your difficulties with banking have been heard, and hopefully with this legislation will now be solved. Thank you, Mr. Chairman.
Thank you, MP Bryson. Just to update, the letter which was sent via the Prime Minister is booked under document IS 319. And the next person on the speaker's list is MP Sarah Westcott Williams. MP Sarah, you have the floor.
Thank you, Mr. Chairman. Mr. Chairman, a very good morning to you, a good morning to my colleagues, a very happy new year to you and yours. It's afternoon, of course, yeah. This meeting was supposed to have started 11 o'clock this morning, and for reasons best known to the chairperson, it could not, and other members of parliament, it could not have taken place. Mr. Chairman, so as I was saying, a happy new year to you and yours, to my colleagues and their families, close and extended, and to St. Martin from this perspective now, from this vantage point of my seat in Parliament, a very good afternoon and Happy New Year. Mr. Chairman, I am sure that in reaction to my next observation, I am going to have some colleague or the other will be able to remind us of a time before that such a setting took place, whether that be so or not. We are sitting here to handle, regardless to who worked on it, who contributed, and who participated, to handle a proposed draft law submitted by the government of St. Martin. They submitted this law. That's what it says, incoming from the government of St. Martin. And the president, without batting an eye, tells Parliament this morning, well, the minister, the one responsible for this law, cannot make the meeting to Parliament, to whom he presented this draft law. No, he can't come. So what are we going to do? We're going to sit here, talk amongst ourselves, have colleagues explain what they think about the law, one, what they feel about the law, and what they are proposing or will be proposing to amend this draft law from the government of St. Martin. And we should sit and say nothing, because if we say anything, we'll hear every story out of the book, those read and unread. We're going to be hearing here today, because we should not say anything, because the first reaction is going to be, oh, you're against having the consumer, the local man and woman who can't have a bank account. You are against them having one, because this law will ensure that everybody can have a basic bank account. Mr. Chairman, I would like to hear from you, the chairperson of Parliament. What is the particular rush behind this draft law? Why? I would honestly like to hear from you why you found it necessary, knowing the Minister of Finance could not be present at this meeting, to still convene this meeting. So we can't have a discussion. No, we're going to sit here, talk amongst ourselves, ask some questions, make up a report, send it to the minister, who will answer it when he feels like. That's what you're telling us here this morning. That's what you're telling me. So, Mr. Chairman, I need to understand from you why today start the handling of this law. Yes, a central committee meeting on a draft national ordinance, a draft law, establishes for the world to know that the handling has started. We started the handling of the draft law in a central committee in which no member of government found it necessary and appropriate to come and face the members of Parliament on a draft law that they presented. That's what we have before us here today. That's what it is. So, Mr. Chairman, if you first can explain me that, because, Mr. Chairman, several members, in fact, more than who signed the letter, were in accordance with the request, the urgent request to the Prime Minister to come to Parliament and explain the matter that is living amongst the population, one of the matters living amongst the population, and that is the issue of the voters' registry. So yes, because of time constraint, MP Lutmila De Weaver, MP Melissa Gums, and myself signed off the letter. But as you would have seen from the attachment to that letter, several other MPs wanted to sign off. But to get it out in time, to get it to the Prime Minister in time so that she could have appeared in Parliament is why only 3 signatures are there with more names appearing on the attachment to that particular request. That's what is living in the population. That's what is living. That's a concern. And Mr. Chairman, then to top it off, you have the heart to call members of Parliament out on this day to discuss this draft law when you know that one of the biggest issues living amongst the population of St. Martin today, the matter of GEBE, for which, again, members of Parliament requested an urgent meeting. And the urgent meeting was held. We started the meeting, and the questions that were asked, we are still waiting on answers. The people of St. Martin are still waiting on answers. Mr. Chairman, you went out to a public event, and you told the people in attendance at that event that you will be calling a meeting on the acrobatic presentation here to Parliament about what is happening on St. Martin, throughout St. Martin. Today, we, the members of Parliament, the people of St. Martin, are waiting on those answers, are waiting on that meeting to take place, to get information from the government of St. Martin. But no, Prime Minister doesn't see the need to come back to Parliament to address a matter like GEBE. The President of Parliament does not see the need to call a meeting on such a devastating report on St. Martin. But here we are today because a survey has shown that a large amount of consumers cannot have access to banking. And the question would be, is it a matter of not being able to do anything with a bank account, and that the persons, even if they had a bank account, they don't have the funds to access it? Is it that? What exactly did the report show besides saying, well, X percentage of the people of St. Martin don't have access to a bank? This member of Parliament on this draft law would like to hear directly, not via, not by presentations in here, from the Central Bank of Curaçao and St. Martin, one, from the Bankers Association on their position taken with respect to this law. Thirdly, what is the Minister of Justice position on this law? One who has been pushing for compliance with the CFATF recommendations. What's the Minister of Justice? You think it would be possible for us to hear from her on that in the context of the CFATF recommendation? Do you think that, Mr. Chairman? Can you respond to that? Mr. Chairman, I cannot, for the life of me, understand why you would take this matter, put it on an agenda. The only point we really got for this week, next week, we receive a letter from the Prime Minister. I saw it. But it's not only about answering questions that the Prime Minister might have heard out there regarding coming back now to the whole civil registry and voters registry. It's about challenging the answers that are being given to members of Parliament. Just like in the case of GEBE, the presentation that we heard here in the first setting of the meeting on GEBE was one of, oh my gosh, you know, things are wonderful. Things are wonderful with GB. Give them a chance. Give them a chance. And then what do we hear? Oh, what do we hear now in the last couple of days? Well, consumers of St. Martin, those of you who have been scared by the announcements of disconnection, it was actually meant for the business community. That's what the Prime Minister said. The notice for disconnection that was sent out in general for the areas of Middle Region, Colby, Simpson Bay, wherever, No. It was actually meant for the business community. If GEBE has a message for the business community of St. Martin, send it to the business community. Their business community, you will be disconnected in Phillipsburg on such and such a date. No, not kind of general notification. And then the consumer on St. Martin, up in arms, scared, don't know what to do for the Christmas holidays. Oh, no, sorry, guys. It was actually meant for the business sector. Well, then tell the business sector so. Why can't you tell the business sector so, but you could tell a consumer? You could tell a consumer. Tell the consumer we cutting you, we disconnecting. It's not meant for you. It's meant for the business sector. Really? Really? And then you come in here to tell me, yeah, let's get a law going on from the to get the people to be able to get a bank account to access banking. Do they have anything to access banking with? Is that maybe why the amount is so high? If we give them access to a bank account, do they have anything to go to the bank with? Is my question. When the government pays out and people go standing in the line, they have a bank account to go collect, for example, their welfare assistance. Do you see the kind of lines that are waiting there only to be told that it ain't ready yet? Does that have anything to do with a basic bank account? Mr. Chairman, as I said, this member of parliament would like to hear directly from those who presented this law to parliament officially. Minister of Finance, I for the life of me, when I heard that the Minister of Finance was not going to be present, I said impossible. Impossible the government would have so much disregard for parliament that they'll tell you, well, you know, you force us to present this law at this time, but we ain't coming. We're going to present it. We're going to sign it. Our name is under it, but we ain't coming to no meeting with parliament. Or you sit down there, discuss it amongst yourself and send us questions. Like, really? Really and truly? Really and truly? So I would like to hear from this put in the report that we're going to be making, the whatever faction you want to call me, put in it that this faction wants to hear from the Minister of Justice in the context of the CAFTF recommendations. One, they want to hear from the minister beforehand. The minister presented a law. Come defend your law. Come defend your law. Come speak to the people. Come speak to parliament. Come defend your law. You presented it. The IS is registered under your name. Come defend it. I want to hear directly from the Central Bank of Curaçao and St. Martin. And I want to hear directly from the Bankers Association, their input that they have given. Mr. Chairman, on the matter of, we got European laws. Surely we have a lot of them. Mr. Chairman, there is a treaty regarding the working of the European Union. And in that treaty, LGOs, which we are, OCTs, LGOs, Landen, Gebieden, Overzees, we have a very particular status. In fact, that status in terms of the territorial working of the EU legislation has been presented in a fact sheet by the Minister of Foreign Affairs. I suggest that this also be taken along in the context of the discussions of this law. Mr. Chairman, no member of parliament owes me an explanation. Who owes me an explanation is the government of St. Martin, the one who presented this law. That the government, again, I am repeating and I'm going to say it again, that the government of St. Martin could show so much disregard for parliament by saying we present a law and you're going to have to deal with it, boo. I can't come today. I ain't coming today on this law. Why? Can we ask the minister why he does not, please put this question in the report. Minister, why did you not consider it prudent to come to defend your law as presented to Parliament? Minister, when do you think it is convenient for Your Highness, the Minister of Finance, to come and present the law to Parliament? Because I, for one, if he decides he come in this afternoon, 6 o'clock, I will be prepared to meet with the minister to hear his defense on the law on the draft law that he presented. He won't come tomorrow morning, 5 o'clock, same thing. But the minister must be able to have an hour to come to Parliament. And so, Mr. Chairman, I would like to hear from you. You, as the representative of the members of Parliament, you owe us an explanation for convening this meeting, one, and the government. I ain't asking no member of Parliament to give me no explanation. None, absolutely. But I am holding the government accountable for their disregard for Parliament, for presenting a law and not showing up to defend the law. So, Mr. Chairman, please put in the report of this Central Committee meeting my questions and those who I would like to hear from on this particular law. And I thank you.
Thank you, MP Sarah Westcott Williams. The next person is MP Christopher Emmanuel. MP Emmanuel, you have the floor.
Mr. Speaker, good afternoon, and good afternoon to my honorable colleagues. Happy New Year's to everyone and the whole entire population of St. Martin. Mr. Speaker, I have taken some time and look at this draft, this law that was presented by my colleague, MP Bryson, and the first time he came to me with it, I told him it will not get my support because over and over, I keep saying it all the time, that the problem we have here in St. Martin is not necessarily the banks, but the central bank. Because it is the central bank that is supposed to do their oversight and supposed to do their regulating or regulation of the banks. And here we are again, where a law is presented where everyone should have a basic bank account. And my colleague and I have been back and forth, and he was like, what it is you would like to see, tell me. And I said, listen, you are telling that you're presenting this law, but what is a basic bank account? What constitutes a basic bank account? Because again, nowhere in it are you saying this is what is needed. Similar to what my colleague Akeem Arundel is asking. Nowhere is it stating, well, listen, a basic bank account requires A, B, C, or D. Again, what we are leaving it up to is for the bank to make that decision as what is a basic bank account. And because of that, I said, listen, I cannot support it because what you are doing is simply turning the coin back upside down. You're leaving it up to the bank. And this is the problem when I said we are to secede from the central bank because we are not getting the proper representation from the central bank. So for me, right, I have reached to a point with my colleague and I'm saying, if you can find it fit to make an amendment or amend the law and say, listen, these are the requirements for a simple bank account. 2 forms of ID and an address. And that's it. That is what constitutes a basic bank account. Then I can see myself in it. In addition to that, I had a discussion with him when I told him, I said, as it is right now, banks are not taking checks. But with your checking account, you can pay GEBE. You can make all the payments you want with your checking account, but you can't do business with your checking account. And that's because the bank made that decision. The banks chose to do that. The banks are the one telling us what we can and cannot do, and the central bank sits on the side, and they do nothing. So these are my arguments, these are my concerns. So again, to the initiator, again, if you can find it, to amend it, where these things can be done, then I can see myself in this law, then I can see myself supporting it. If not, then it will not get my support. I hope the government, I hope the initiator, I hope my colleague understand what my concerns are with this banking law. To me, it doesn't have enough teeth. It doesn't give enough to the individuals or the 20% in our society who doesn't have a basic bank account. There should be a definition of what constitutes a basic bank account and what is needed, that the banks can understand that when someone walks into the bank and say, I would like to open a bank account. Now the bank don't tell them, you need to bring a bill from GEBE. The bank don't tell them, you need to bring where your mother is working. You need to bring what car insurance you have. You need to bring a letter of inheritance. You need to bring 2 last job pay slips. You need to bring this and bring that and bring that and bring that and bring that. No. It needs to be that the banks can understand, okay, you need to have 2 forms of ID and your address. That is what constitutes a basic bank account. And if that can be amended, if that can be part of it, then I can see myself supporting this banking law. If not, then I can't. I thank you very much, Mr. Chairman.
Thank you, MP Christopher Emmanuel. The next person is MP Melissa Gums. MP Gums, you have the floor.
Thank you, Mr. Chairman, and good afternoon to you, Rifir, my colleagues, and those joining us online, and Happy New Year to all. For now, I just have 2 questions related to this law. And the first would be to touch on what MP Bryson said about Article 5, stricter conditions before ending a relationship with a customer. How would this article then relate to AML legislation, so anti-money laundering legislation, where banks now have to provide a reason for rejecting an account, whilst most AML legislation prohibits a tipping off type of scenario? And then the second question for now, so from the government side, I've previously asked about the possibility of establishing better identification track histories for citizens. So something in line with like the BSN ID that you get in the Netherlands or social security number, to use a closer example from the United States. If we look at banking in the Caribbean as a whole, this remains a challenge. A proof of address is a proof of address, but it doesn't mean you're at that address. It's very tough, and it's, I can't think of a different word to use, but it's very tough to track people and their movements financially, and just physically on the island. And that has been a complaint of the banks, not just here, but everywhere. So the response received at the time was that this was being worked on, so I would request an update from the Minister of Finance, who answered that question previously, as to where we are in that process. Thank you.
Thank you, MP Gums. The next person I see is MP Bryson. MP Bryson, you have the floor.
Thank you, Mr. Chairman. Mr. Chairman, yesterday we had I would say, a very fruitful debate amongst the leaders of the political parties. And one thing that I took from that, and I think it was MP Gums who mentioned that, you know, we should do more debates like that as leaders and as parliamentarians in general, and I agree. In a meeting like this, where in a central committee, the real only ultimate requirement is that a report is drawn up where the minister must respond to all the questions and concerns of the members of parliament, this is a moment where I would enjoy having a debate. Because in the debate yesterday, you know, one of the things that was a very good admission that was made is that the Democratic Party was the authors of the monetary union. And Mr. Chairman, I said that is a good admission, because the 2 biggest issues that we've gotten out of that monetary union was what is happening at Enya with Ansari and Mullet Bay, and what we're dealing with today, the unmitigated disaster that we've had in our country, where the banks have been allowed to operate basically without any sort of consumer protection legislation. So, Mr. Chairman, maybe the debate feeling is still there, that now the debate is over, we have to try and win it again today. Mr. Chairman, I'm tired of wasting my time having to address the excuses that come from people who just want to vote against for voting against sake. Mr. Chairman, if the biggest problem of a member of parliament is that a minister ain't here, when the minister has to be present for the public meeting, when the minister has, or the government as a whole, I agree. I think we should hear a good question posed about Ministry of Justice, but does the Minister of Justice have to sit here to give us this question? We've had that discussion in faction leaders, that we should do like how Curacao and Aruba do. They don't even broadcast their central committee handlings of the law. The minister sometimes only sends the technocrats, because this is a technical discussion on the technicalities of the law. So, Mr. Chairman, I think you have handled this in the right way. I don't have an issue with it. Maybe I'm biased, because yes, this was a co-legislated law. I might have initiated it with the support of Parliament. We then asked the government to vet it. Because what is the feedback I've gotten in the past? Oh, you drafting these laws and they're not good. Okay, you know what? Then let me ask the central bank to help me with it. Then you do that, it's still a problem. So, Mr. Chairman, the end result is this legislation is here to create a basic bank account. There are some legitimate concerns that I also look forward to hearing from the minister regarding exactly their vision in terms of what the central bank's point was in terms of the requirements. I get that part. But we still have the opportunity to make amendments. MP Arundel has proposed some, MP Emmanuel has proposed some, has proposed some. Now we're talking. Now we're being parliamentarians, Mr. Chairman. So at the end of the day, I think everybody understands what the purpose of this is. To make sure that 20% of our population have access to a bank account, don't have to put it under their mattress or in their couch or do pad in the hand to try and keep the money safe. And Mr. Chairman, there was an interesting analogy I'm going to have to borrow from MP Emmanuel that I want to bring up at the time that he brought up. And it got me to thinking what's going on in our country. We have companies that don't have bank accounts, that are told you can't have a bank account. But you know what is very strange? The same bank, the tax department, has to collect all that same money in cash, and guess where that cash goes? To the same bank that say you can't have a bank account. The same money that's suspicious. Mr. Chairman, it's a double standard that does not make sense in our society. So that's why I must say thank you to MP Emmanuel for having at least somewhat of a change of heart in his position. I have also had a change of heart inspired by him with regard to the central bank. Because after seeing what has happened with this Enya debacle and uncovering the corruption that took place by the hands of Ansari and his cohorts, placed there strategically by people who were in power to make sure he could continue to do what he does, you can't fix the central bank no more. There's no replacement of board or new presidents can fix it. The only ultimate solution is St. Martin should have its own central bank. However, even if it's our central bank, that central bank will have to operate under our legislation. So the need for laws like this, be it a monetary union or our own central bank, this law prepares St. Martin for its own central bank. That is the way I see it. So, Mr. Chairman, again, I think some of the questions posed definitely make sense. I did take note of, if I can comment, and again, indeed, I don't owe answers to members of parliament here, but I think we should have more debates on these type of issues and have those interactions whether a minister is here or not. But what I can say is that the point regarding the AML and so on was a very major part that was analyzed within the explanatory memorandum, because there was that back and forth with the FATF and so on to make sure, and that is why the penal provisions, those 6 penalties, those 6 crimes that would allow you to not have a bank account are in line with those AML, which is basically money laundering, misappropriation of funds, those different things could allow the banking relationship to end. But those are questions, I think, yes, let's get them from the government, and then let's allow this legislation to move forward, not for us, but for the people that have been crying out for members of parliament to stand up and make sure that the banking situation in our country is solved once and for all. Thank you, Mr. Chairman.
Thank you, MP Bryson. The next person I see is MP Sarah Westcott-Williams. MP Sarah, you have the floor.
Thank you, Mr. Chairman. Once again, Mr. Chairman, I just wanted to know if you will respond to the questions I posed to you with respect to this meeting. In terms of the minister not appearing, will you be requesting that he does? Are we just going to close it off the way, close off this reporting the way it has been done? Are we going to get the persons who feel they are initiators of this law sit in front of us so that we can have a debate as it really takes place between Parliament and the initiator of a law? So if you could provide some clarity, Mr. Chairman, in your capacity as chairperson of Parliament, that would be very much appreciated. And respond to the question about the Prime Minister's refusal to come to Parliament and address the questions posed on the matter of GEBE. Thank you, Mr. Chairman.
Thank you, MP Sarah Westcott-Williams. I would surely respond to you in writing after consultation with my SGs. And the next person is MP Grisha Halliger Martin. MP Grisha, you have the floor.
Pleasant good afternoon to you, Mr. Chairman. Good afternoon to our SG. Good afternoon to those listening, viewing online, and a happy new year to everyone in St. Martin. I wish everyone a prosperous new year ahead. Mr. Chairman, unfortunately, it's unfortunate that you are unable to answer the question, Mr. Chairman, because I was actually looking forward to some sort of response, at least a ounce of response as to why you've allowed to not have the minister here present with us to present his law that he presented to Parliament. I can't understand. This is like new for me in the 4 years in Parliament, that you present the law and you just go and zook it out, zook it maroid, ask whatever question you have, I ain't there. I ain't there to present nothing. I mean, I don't get it, Mr. Chairman. Why did you allow this meeting to happen? You can't answer that for yourself. You need to talk to the SG for that, Mr. Chairman, to find out why you decided not to allow, not to continue this meeting without the Minister of Finance. In addition to all the questions posed, I just have a suggestion, or I don't know if the government is maybe considering this. My question / suggestion then would be, maybe if it's already considered, then kudos to the government for that. If a brand new company receives a business license to operate from government, can that brand new company automatically receive a bank account one time to do at least banking locally? That they don't have to go through the whole whatever process it takes, that it comes automatically once approved. You get an account automatically to do your business transactions locally. If you need to do anything internationally, if there's any other forms of or so that they need to fill out, then fine. But if they would consider having that pegged or tied to giving out business licenses. That's all I have for you now, Mr. Chairman.
Thank you, MP Grisha Halliger Martin. Yes, I would like to just answer you on the point you raised that we're continuing with this meeting without the minister. I just want to confirm that I remember this has happened previously. We have had meetings before, and the ministers were not present, and quite a bit of clarity was given with MP Bryson. I thought we all understood. If we can have a debate about it, and our questions will be answered. Whether the minister is here or not, he gets the questions. So to limit the time, I believe the step what we did was good. People are suffering, and that's what we have to count. And with this, if there are no more comments, no more. Oh, MP William Marlin. MP Marlin, you have the floor.
No quorum. No quorum. Mr. Chairman, there is no quorum.
Please. How many are there? 4, 5, 6, 2. Thank you for the quorum. MP Marlin, you may continue.
Thank you. Ay. You didn't say so on the radio yesterday or this morning. Oh, that wasn't you, okay. Thank you, Mr. Chairman. And Mr. Chairman, through you, I would like to extend a Happy New Year to all colleagues in Parliament, staff of Parliament, but also through you to the people of St. Martin. A healthy, prosperous, and bright new year. As it is for me, my year is coming to an end on February 10th, whenever it will be, when the new Parliament will be sworn in. There will be 15 new members, and I will not be part of it. Several members will be returning, I would hope, and I just want to take use of this opportunity. But, Mr. Chairman, as we are here discussing, there are two issues I want to raise. I agree that the central bank should step up to the plate and get more involved in the protection of our people where banking is concerned. The banks are unanimously, unceremoniously at times, implementing certain fees. We have seniors who have a little savings account and they have not been depositing for a while for whatever the reason may be. But there are banks that say if your balance drops below X amount of money, then they withdraw exorbitant fees like 35, 50 guilders or whatever it is, service charges for having a bank account that there isn't constant deposits and withdrawals on it. So when these people now think that they have 500, 600, 700 guilders on their little savings account, which for them is a humongous amount of money, then they find out their bank account was actually sort of liquidated. Because if you keep withdrawing 35 guilders or 55, I don't even know the amount of money. But if the banks keep withdrawing, then at a given moment, there is nothing left. Mr. Chairman, I have had an unpleasant experience. We know we are PEPs, politically exposed persons. My daughter in Holland had to do a transaction and had to fill out a whole bundle of forms because she's a PEP. My son had accounts that were closed because he is a PEP. And I went to the bank some time back, it's more than a year ago, to open a second account at a bank where I already had an account. And the lady who helped me was very pleasant, and we had a nice discussion. She even gave me, up till this day, I have it in my pocket, in my pocketbook. She gave me the number of my account and told me, Mr. Marlin, next week, you will get your card. It will take a week before everything is finalized. And she said, but in advance, this will be your account number, 813005 or something, but it doesn't really matter. And then she said, by the way, you're a PEP, right? I say, yes. She said, well, you have to fill out these forms. And she gave me the forms, and I started filling out the top of the form. And she said, I don't mind you spending additional time in my office, but you can't fill out all of this information anyhow. So we can continue chatting, but you can't fill it out here because there is information that you would need. And to my surprise, to open a basic account, it was no business account, to open a basic account, I was told, because I'm a PEP, I need to submit all information on all my movable and immovable goods, cars that my wife and I own, the value of those cars. I need to bring an updated appraisal of my home. I need to bring, and I need to bring, and I need to bring the whole neighborhood and my grandparents in order to open this account. And I jokingly said, well, you know what? I will save you the time of having to shred them since I already started filling it out, and I will assist, and I manually shredded them and tell her, no personal offense to you. You're doing your job, but this is ridiculous. Because here we pass legislation on the MUT. Here we pass legislation on all kinds of things. And the banks, it's not a favor they will do, or they need to look the other way. The banks have to monitor all unusual transactions. You submit it to the MUT, and the MUT have to submit it, if they feel there is something wrong, to the public prosecutor. And they have to do their job. The bank doesn't have to decide who should or who shouldn't. Because if I have an account, and the only deposits to that account is my salary, then, and my pension, then that's all. The minute the bank sees a deposit, whether it's from here or overseas, and particularly if it's about, let's say, $5,000, $10,000, $20,000, hey, that's a red flag. And you can call me in and say, Mr. Marlin, there's a transfer of $20,000, $30,000. Can you explain this? I would say, yes, my grandfather died in Japan three weeks ago, and because of the settlement of the estate, here are the documents, and my share of it is $300,000, but this is an initial deposit. If the bank doesn't believe me, they're allowed to submit it to the MUT, and the MUT does their investigation, and if that is not satisfactory, so that is how the system was made to operate. Now, I understand, yes, most of our banks are Canadian banks. St. Martin is a very small jurisdiction in their whole global setup, and they are afraid of being fingered for money laundering and this kind of thing and trafficking. So they don't want to spend too much money and too much time on a couple of accounts in a very small jurisdiction. We are smaller than any little village in Canada. So I can imagine from that bigger perspective, but then our central bank needs to set up, warn us timely and say, well, hey guys, St. Martin, Curacao, you guys better move to opening your own banks and ensure that we can protect our people better and better than they are protected right now. Mr. Chairman, as far as the discussion is taking place about the minister must be here present, Mr. Chairman, one of the things that it's a pity that we have not been able to finalize it, is the change to the integrity chamber law, where it is advised to raise the age to allow people above 70 to serve on the integrity chamber law because they were running out of people who were available. Mr. Chairman, together with my colleague, MP Bryson, we were considering for the further handling of the law. It was put on hold because I, for one, said it would not have my approval unless we change the law to make it mandatory that all persons who are on the board of the Integrity Chamber are residents of St. Martin. Mr. Chairman, I did not take part in the debate on the Integrity Chamber law, but I am pretty sure that when that debate took place, there was no minister from St. Martin defending the law. I can't remember if when the Central Committee, or even if there was one. Because you know what's interesting, Mr. Chairman? One of these days when I finish penning my memoirs, this is one of the things that will stand out in it. That the Dutch government, after 2017, forced the Integrity Chamber law, their version of that law, on the government of St. Martin in exchange for funds to assist with the rebuilding of the country. And when I opposed it as Prime Minister and said it was an indecent proposal, it was wrong. And I even had a discussion then with members of Parliament. But because there was such a rush to use the hurricane to overthrow the government and to use the Integrity Chamber as William Allen is blocking the law, and therefore, his ego and his this and his that, and is preventing the people, while, Mr. Chairman, we go up by the governor and take an oath to defend the Constitution, and we will vote our conscience, and that we have made no promise to no one. But, Mr. Chairman, you know what happened then? No discussion with the minister on the law. Members who wanted to support a new government agreed with the Dutch government that they will support the version of the Dutch government of the Integrity Chamber law, will vote for it. And it wasn't voting their conscience. It was voting the Dutch conscience, all in name of, oh, we need help. Oh, we need help. You know the consequence of it, Mr. Chairman? Up till today, the ripple effects are felt throughout Curaçao, Aruba, and Curaçao and St. Martin, and even Aruba, that had 30 years of autonomy, and an autonomy that Holland was respecting, have been dragged into the new way of dealing with the autonomous countries in the kingdom by imposing more and more and more on them, demanding more and more of their authority, because they were willing to give in. They were willing to exchange their vote and have a vote based on a request by the Dutch government. And Mr. Chairman, now we want to make sure that ministers are here. And if ministers are here, the meeting shouldn't continue. But in the absence of your Prime Minister, who should have been submitting the Integrity Chamber law, you agreed and passed a motion that you will sign on to that Integrity Chamber. Mr. Chairman, I thank you, and I close on this note.
Thank you, MP William Marlin. If there are no more comments, a report will be sent to the government on this draft national ordinance. Ladies and gentlemen, we have come to the end of this meeting, and I hereby close this meeting.